It's 11:30 p.m. You're driving home. Maybe you just left the range. Maybe you're coming off a late shift. You're a law-abiding citizen. Your permit is valid. Your firearm is properly stored. Everything about your situation is completely legal. Then you see it. Red and blue lights flashing in your rearview mirror. Your heart jumps. That's normal. Adrenaline hits fast in moments like this, but you aren't panicking because you know you haven't done anything wrong. You pull over. You roll down your window. The officer approaches, asks the standard questions, and then asks if there are any weapons in the vehicle. You decide to be honest. You tell him yes, you have a legally possessed firearm in the car. And in that exact moment, the ground shifts beneath you. Before a landmark Supreme Court ruling changed everything, that one sentence, that one act of honesty, was being used by departments across the country as a golden ticket. The mere mention of a gun meant your Fourth Amendment rights effectively ceased to exist. Officers would use the presence of your Second Amendment right to erase your Fourth Amendment right to privacy. They would order you out, toss your car, and leave you on the side of the road in handcuffs while they investigated a crime that didn't exist. And the most terrifying part? Lower courts were saying this was perfectly fine. A Supreme Court decision just came down in a unanimous 9-0 ruling. Not a narrow victory, not a 5-4 split along political lines. All 9 justices, from the most staunch conservatives to the most staunch liberals, agreed. When the entire court agrees on a matter of constitutional law, the message is unmistakable. The lower courts were dead wrong. And if you carry a gun in your vehicle, what the court said changes the legal ground beneath every traffic stop you will ever have. For years, a dangerous legal rot was spreading through the justice system. It was a conflict between 2 of the most foundational liberties in the Bill of Rights. The Second Amendment, your right to keep and bear arms. The Fourth Amendment, your right to be free from unreasonable searches and seizures. 2 separate guarantees, 2 foundational protections, 2 rights that were never meant to cancel each other out. But here is what was actually happening on the ground. Some courts had created what legal scholars began calling a gun exception to the Constitution. The logic went like this: guns are inherently dangerous, so when an officer becomes aware that a gun is present, the totality of the circumstances automatically shifts. The safety interest of the officer overrides the privacy interest of the driver the moment a firearm is disclosed. On paper, that sounds almost reasonable. In practice, it meant millions of law-abiding gun owners were being forced into an impossible choice: be armed, or be protected by the Fourth Amendment, not both. That is not how constitutional rights are supposed to work. You do not trade one right to exercise another. The Bill of Rights is not a trade-in system, and that exact conflict is what made its way to the highest court in the country. The case started exactly the way so many of these cases begin: a routine stop. The driver was cooperative, calm, not reaching for anything, not threatening, not erratic. He was legally armed, but the officer treated the gun like justification to search everything: glove box, back seat, trunk, closed containers. The argument was simple. Guns can be dangerous, therefore the presence of a gun creates safety concerns, therefore a search is justified. Lower courts agreed, and then the Supreme Court of the United States stepped in, 9-0. No dissents, no partial disagreement, no split reasoning. The court stated in no uncertain terms that the mere presence of a legally possessed firearm does not constitute probable cause for a warrantless vehicle search. Let that sink in. The highest court in the land officially declared that being a gun owner is not suspicious behavior. Carrying a weapon for a lawful purpose is not evidence of a crime, and law enforcement cannot treat it as such. The court went further and made something else clear. You cannot use a citizen's exercise of one constitutional right as justification to strip them of another. But here is where you have to slow down, because this is where most people misunderstand what a ruling like this actually does, and does not, do. This decision does not make you untouchable. It does not eliminate police authority during traffic stops. It does not remove the automobile exception to the Fourth Amendment. It does not mean officers can never search a vehicle that contains a firearm. What it means is more precise than that, and that precision matters enormously. A legal gun, standing alone, is not probable cause. That is the line the court drew. Those 2 words, standing alone, are doing enormous work in this ruling, and if you miss them, you miss everything. Here is the reality on the ground. The Supreme Court does not patrol your neighborhood. A 9-0 ruling is powerful legal precedent, but it is not a physical barrier. It does not stop an officer from asking for consent. It does not fix outdated department training manuals overnight. It does not prevent a hunch from turning into a roadside interrogation. There is always a gap between the law on the books and the law on the street. And that gap is exactly where things go wrong for people who think a courtroom victory automatically protects them at the roadside. The first situation where this ruling offers no protection is prohibited possession. If someone is legally barred from owning a firearm due to a felony conviction, certain restraining orders, or other disqualifying factors, the presence of a gun is no longer innocent. It becomes potential evidence of a crime. The court's ruling protects lawful possession. It does not protect unlawful possession. If an officer has specific reason to believe you are prohibited from carrying, the gun transforms from a constitutional right into potential contraband. That is not a loophole. That is a completely different legal situation. The second situation involves visible violations of state law. Every state has its own firearm regulations. Some require guns in vehicles to be unloaded. Some require locked containers. Some restrict where they can be placed inside the car. If your firearm is in plain view and clearly being stored in violation of your state's law, that creates probable cause, not because guns are suspicious, but because the manner of possession may be illegal. The gun itself is not the issue, the violation is. That distinction matters enormously. The third situation is where traffic stops escalate most often. Additional suspicious behavior. Imagine you are pulled over and disclose a legal firearm, but during the interaction, the officer also observes drug paraphernalia in plain view, or smells illegal substances, or hears contradictory statements about where you've been, or sees you attempting to conceal something under the seat. Now the firearm becomes one piece of a broader picture. The Supreme Court did not abolish the automobile exception. Independent evidence of criminal activity still creates probable cause. What the court clarified is this: a legal gun alone is not enough, but other factors combined with that gun can be. That line is critical. Now let's talk about the single most common way this 9-0 ruling gets bypassed every day. And it has nothing to do with officers ignoring the law. It is consent. Officers are trained in roadside psychology. They are not always going to demand to search your car. They are going to ask, and they are going to make it sound like it is not really a choice. They will say things like, "You don't mind if I take a quick look around, do you?" Or, "If you have nothing to hide, there shouldn't be a problem." Or, "Just for my safety, I'm going to check the cabin real quick, okay?" The moment you say yes, even casually, even just to seem cooperative, the 9-0 ruling disappears. By giving consent, you have waived your Fourth Amendment rights in that moment. You have told the government, "I am giving you permission to ignore the Constitution." Most people give consent because they want to seem like the good guy. They think that cooperation means letting the officer look. But here's what you must understand. Cooperation and consent are two completely different things in the eyes of the law. You can be the most polite, respectful person that officer meets all week while still firmly saying, "Officer, I do not consent to any searches." Refusing consent is not suspicious. Refusing consent does not create probable cause. The Supreme Court has long held that a citizen's refusal to allow a search cannot be used as evidence of guilt. It is a protected exercise of your rights. If you hand over the keys to your privacy voluntarily, the 9-0 ruling cannot help you. There are two other legal backdoors that can render this ruling useless if you are not prepared for them. The first is the plain view doctrine. The court ruled that a legally possessed firearm is not probable cause, but if that firearm is stored illegally, sitting on the passenger seat in a state that requires a locked container, the officer is not looking at lawful possession, he is looking at a visible violation. The 9-0 ruling protects the lawful gun owner, not the one who ignores state storage requirements. The second is the officer safety frisk. Courts have long allowed officers to conduct a pat-down of a person's outer clothing if they have reasonable suspicion that the person is armed and dangerous. Notice those two words, armed and dangerous. Before this ruling, many officers treated armed as automatically meaning dangerous. This 9-0 decision creates a wedge between those two concepts. Being armed is a right. Being dangerous is a behavior. But if you are reaching toward areas the officer cannot see, acting erratic or being hostile, you are providing the dangerous component that justifies a frisk, and potentially a search of the area within your reach, regardless of what the court said about legal gun ownership. This is why your behavior during the first 60 seconds of a stop matters more than the legal arguments your attorney will make 6 months later. Officers are also trained to look for indicators of criminal activity in your demeanor. Shaking hands, avoiding eye contact, contradictory answers. If you create a high-tension environment, you are practically handing the officer pieces of a probable cause puzzle that has nothing to do with your gun. They might note the odor of marijuana or claim they observed furtive movements. Once any of those factors enter the picture, the 9-0 ruling becomes irrelevant. So let's talk about exactly what to do when those lights come on. The moment you see them, you are entering a chess match where the officer has the home court advantage. But you have the Constitution. Here is how you protect yourself from the first second to the last. Pull over in a well-lit area. Turn off the engine. Roll down your window all the way. If it is dark, turn on your interior dome light. Place both hands visibly on the steering wheel at 10 and 2. Do not reach into your glove box as the officer approaches. From the officer's perspective, reaching equals danger. Your goal in the first 60 seconds is to communicate one thing without saying a word. You are not a threat. When the officer asks for your license and registration, do not immediately lunge toward the glove box. Pause. Keep your hands visible. Speak first. Here is the exact language to use. Officer, for your safety and mine, I want to let you know that I am a law-abiding gun owner. I have a legally possessed firearm in the glove box along with my registration. How would you like me to proceed? Notice what that accomplishes. You did not blurt out, I have a gun, in a way that creates alarm. You framed it as lawful possession. You demonstrated awareness of the officer's safety. And you asked for instructions, which places the interaction on cooperative ground. Under the 9-0 ruling, that disclosure alone cannot be the basis for a search. Now, and this is where everything either holds or collapses, if the officer then says he would like to search the vehicle, you must be ready with a clear, calm, firm response. Officer, I respect your job and I want to be cooperative, but I do not consent to any searches of my person or my vehicle. I am happy to comply with all lawful orders, but I am not waiving my Fourth Amendment rights. That is it. No speech, no roadside constitutional seminar, no argument. Just a clear, respectful refusal. You are not required to explain your reasoning. You are not required to justify your decision. Refusing consent is a protected right. If the officer orders you out of the car, get out. The Supreme Court has already established that officers can order you out of a vehicle for their safety. Getting out is compliance with a lawful order. Letting the officer search is consent. Know the difference. You can step out of the vehicle, stand calmly with your hands visible, and still say clearly, I do not consent to a search. Now for the hardest scenario. The officer searches anyway. He claims he smells something. He says it is for safety. He believes he has probable cause for other reasons. This is the moment that decides everything, and the instinct to argue or physically interfere is the instinct that turns a winnable court case into a criminal charge. Do not interfere. Do not reach. Do not attempt to block access. Do not touch the officer. Do not raise your voice. Instead, if there is a body camera or a dash camera running, say this loudly and clearly. I am standing here peacefully. I am complying with your orders, but I want it clearly on the record that I have explicitly refused consent for this search, and I am only submitting to your authority under protest. That phrase, submitting to authority under protest, is not just words. It is a legal marker. It is the difference between acquiescence and objection. It proves you did not waive your rights. It demonstrates the officer acted on his own authority, outside the boundaries the Supreme Court established. It gives your attorney the foundation to challenge every piece of evidence recovered from that search. You do not win constitutional arguments on the shoulder of a highway. You win them later in a courtroom, if necessary. And that only works when you kept your composure at the roadside. Once the stop is completely over, document everything immediately. Write down the time and location. Write down the officer's name and badge number. Write down exactly what was said, in what order. Record whether you clearly refused consent. Record what justification the officer gave for the search if one occurred. Memory fades faster than most people realize. Details win cases. There is one final layer to this that most people overlook completely: the geography of your rights. The 9-0 ruling is a federal standard for the Fourth Amendment, but it does not fix the patchwork of state gun laws. If you drive from a constitutional carry state into a state that requires a permit, and you do not have that permit, the ruling will not save you. In that state, your possession is unlawful. The Supreme Court's protection is a shield for the law-abiding, not a cloak for the law-breaking. Before you cross a state line, you must know whether that state has a duty to inform law. You must know the storage requirements. You must know whether your permit is recognized through reciprocity. You must know whether your magazine capacity is legal in that jurisdiction. If you are in violation of a local gun law, the officer has probable cause the moment he sees the violation. At that point, the 9-0 ruling becomes irrelevant. Ignorance of state-specific law is not a constitutional defense. Being a responsible gun owner means understanding the laws of every jurisdiction you enter. Research reciprocity before every trip. Understand storage requirements. Maintain valid permits where required. Because the protection this ruling provides only works when your possession is genuinely lawful. Here is the bottom line. The Supreme Court made something clear that should never have needed clarification. You do not lose your Fourth Amendment rights simply because you exercise your Second Amendment rights. You can be armed and still be fully protected from unreasonable searches. That is a significant constitutional affirmation and a direct rebuke to every lower court that treated gun owners like second-class suspects. But a court ruling is just words on paper until it is applied on the street. Rights are not self-executing. They require people who understand them, who respect them, and who know how to exercise them correctly under pressure. The ruling is your shield, Your behavior is the hand that holds it. Calm hands, clear communication, no sudden movements, no voluntary consent, no roadside debates. Know your state's laws, stay lawful, stay composed, because most people will never hear a breakdown like this until after something has already gone wrong. After the search, after the arrest, after the charges. You heard it before that moment ever arrives. Stay informed, stay calm, stay disciplined. Because in this country, rights are strongest when the people who hold them know exactly how to use them. And the next time those lights flash behind you, you will know exactly what to do. This is educational information about constitutional law and is not legal advice for your specific situation. Laws vary by state, and the specific facts of every encounter matter. If you face a legal issue, consult a qualified attorney in your jurisdiction.